Awesome. Should have asked that first. Sorry, David. Rosalie, would you please do a roll call?
Chairman Loper. Vice Chairperson. Member Ward. Present. Member Cardin.
Present.
Member Schwartz. Chairman, we have a quorum.
Thank you very much, Rosalie. Time for the announcements.
Sorry, Chairman Loper. Rosalie, this is Heather. I'm here, but my dogs just got out. I need to go get them and then I will be back. I'm sorry.
Okay. Thank you.
Life happens. Good luck chasing them. I'll move on to the announcements. This meeting has been noticed in accordance with the open meeting laws of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office, and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. More on that in a moment. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony on a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card if you're here in attendance. Looks like this. You can get it from Rosalie and fill that out, please. Or if you are registering desire to comment on the published agenda if you are online. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed to testify shall be at the discretion of the board chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. Votes will be done by roll call vote only, and the chair will verbally identify the specific members responsible for all motions and seconds. Before I go into the minutes, there is going to be a change to the agenda. Item number 1, BA 2022-036 for the Wise Family Trust, moving it to the end of the agenda because I have to leave by noon, and I also will have to recuse myself on the matter. Moving on to the minutes. Has everyone had a chance on the board to look at the minutes for October 13th, 2022? And if so, are there any questions or comments or changes? Seeing none, the motion or the minutes are approved. Staff, any updates on the agenda?
No.
Okay. And I already mentioned I have a conflict of agenda. Item number 1, we'll move on. All right, we'll move on to the regular agenda. That's a good point. Darren, we note in the agenda that item number 5 is to be continued.
I apologize.
Oh, you know what? That's an older version. I apologize for that. It's not on this. Darren, did you have anything you wanted to say on that item?
I apologize. I am out of sorts at the moment. Whose case is that? Yes. Is it to be continued? Yeah. I'll go ahead and just tell them. Yeah.
Yes, the applicants for BA 2022-056 request the continuance of that case to the, I believe, the January 19th hearing.
Correct,
no action
on
required.
Okay, cool. All right, then we'll move on to regular agenda item 2, which is BA 2022-053, the Thomas property, which is continued from our meeting in October. Staff, Joel?
Good morning, Chairman Loper, members of the board. Agenda item number 1 is for subject case VA 2022-053, which is a variance request for an RU43 zone property located at 5943 East Rancho del Oro Court in the Lone Mountain Ranch subdivision near Cave Creek in Supervisory District 2. Approving this request would have the effect of allowing for a 23 feet east side setback where 30 feet is the minimum permitted to clear a violation caused by the improper placement of a garage addition on the lot. Next slide, please. The subject lot was created as part of the plat for the Lone Mountain Ranch subdivision in 1997 and has maintained its original bounds since then. The current owner took possession of the subject property in 2017. In July of 2020, a contractor employed by the owner filed for building permit B 2020-06035, which indicated the attached garage would have a 30-foot setback to the east in compliance with the base ordinance requirements. This site plan was approved and construction of the garage concluded without further incident in March of 2021 upon final inspection. Next slide, please. In June of that year, there was a violation case filed by a neighboring resident indicating the garage was built 7 feet closer to their parcel line than what was approved by the county. Documents provided to the county show that the owner had presented a site plan to the HOA of Lone Mountain Ranch, which indicated a 23-foot, 7-inch setback on the east side of the property at the eastern bound of the garage addition, and an existing 36-foot, 1-inch setback on the west side of the property, matching the setbacks of what was ultimately built. The HOA subsequently rejected this original site plan, stating in part that it did not meet county requirements. The owner then presented a new site plan, which indicated 30-foot setbacks on both the east and west to the HOA and then the county, which were then approved. Next slide, please. The county opened the current violation case against the owner in June of 2022. This led to a civil hearing on the matter on November 8th of this year, in which the owner was found to be responsible for the violation. Next slide, please. Staff would note that the neighbor who originally filed for the violation case is now in favor of the project per documents received after the publishing of the staff report, and there's no other known opposition. Next slide, please. Staff is recommending denial on VA 2022-053. Even if you strip away the context of the violation case, staff believes the owners failed to demonstrate a peculiar condition of physical hardship that would otherwise prevent development. The lot has maintained its bounds since the original plat and is already substantially developed, thus indicating that there would be little impediment to building compliance with the ordinance. Staff would note that detaching the garage from the primary residence would negate the need for a variance. Finally, in the context of the violation, staff believes that any hardship incurred by the homeowner in this matter is entirely self-created in the line title. Staff believes the homeowner and or his agents were aware that what was submitted to the county portrayed the site incorrectly. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion in a motion to grant the relief sought. And at this time, I'm happy to answer any questions.
Thank you, Joel. Great presentation. Are there any questions of staff? Member Schwartz?
So doesn't thank you for the presentation. Doesn't county inspections go out and do inspections to determine the setbacks and whether the site's being laid out to meet those guidelines?
Chairman Loper, Member Schwartz, that is correct. And unfortunately, in the process of inspecting the property, the improper setback was not found at that time.
So explain that again. The improper setback was not noted at the time. So yeah, go ahead.
Yeah, Mr. Chairman, Member Schwartz, it passed the footing setback inspection based upon the plans that were provided. It was built in accordance with plan. The plans erroneously illustrated the property line, and in the field, the property line is not clear unless it was pegged, because the neighbor's fence and landscaping do not follow the property line. They're set inside the property. So the site plan indicated a property line that was, and I believe we have it laid out in here, it indicated a 30-foot setback that would be generally along the edge of their pavement. However, it's only 23 feet. So the building was built according to plans 23 feet long from the side of the existing building, but that was illustrated as being 30 foot from the property line, and it's 23 foot.
So the engineer then used the wrong line in as he laid out the house on his plans. Is that what I'm hearing?
The person that prepared the site plan for the applicant illustrated the line incorrectly.
And when a house comes through or a building comes through the process, what's the check and balance in place to confirm that those lines that are being delineated are accurate? Or are we just reliance on the surveyor?
We are in heavy reliance on the veracity and the accuracy of the site plan submitted. There are opportunities for catching those type of things by a detailed scaling out on aerials and comparing that to the site plans. In this instance, that was not caught, and the garage addition was issued a permit, and the permit was finalized.
Okay. All right. Thank you.
Thank you. Any other board members have any questions of staff at this time? All right, I'm going to go ahead and open the public hearing. Is the applicant or applicant representative either here in person or, okay, come on up and please provide your name for the record and go ahead.
Thanks so much. Good morning, board members, staff. My name is Mary Grace McNear. I'm with the law firm Buse Gilbert McGroder, and I represent Michael Thomas. Michael and his wife are here with us today. They live at 5943 East Rancho del Oro Court in the county. And we're here, as you know, seeking an ordinance or seeking a variance. If you could, okay, there's our slide. Great. Can we go to the next slide, please? This is what the garage looks like, the addition onto the Thomas's residence. They hired Arizona garage builders in May of 2020, and they received approval from their HOA in June. The county approved their plans in July, and the intent was to basically build expand the attached garage so that the house looks balanced. And of course, they considered that it would be good for the neighbors. Unfortunately, if you go to the next slide, please. In the course of construction, they realized that they were encroaching onto their neighbors to the east. That's Ms. Smith's property. They had to rerun utility lines. I mean, obviously, Mr. Thomas and Mrs. Thomas didn't do anything themselves to measure or gauge. They hired Arizona garage builders. They removed, in the course of setting this encroachment right, they started to build it onto Ms. Smith's property. And it's in the course of setting that right, they removed some of her desert vegetation. And that devolved into a dispute between the two neighbors, which has now been settled. You guys have been aware of that by my letter and the letter from Ms. Smith that was submitted. If you go to the next slide, please. I was just going to point out, as you did, Board Member Schwartz, that plans were approved by Maricopa County. There were numerous inspections. I mean, you know, my client is the least educated in terms of building here, and nothing was caught by either the county or the garage builders or the engineer. The garage was finished in spring of 2021. So if you go to the next slide, please. Okay, so here's where we stand. The dispute with Ms. Smith is settled. The garage is complete and it encroaches 7 feet into the 30-foot setback. I was supposed to have Josh Felt here as my witness. He's the one who actually measured the setback. But apparently Mr. Felt isn't here today. And so I included with my letter to the board, an email from Josh's attorney. The AGB was involved in the dispute between Mr. Smith and Ms. Thomas, or Ms. Smith and Mr. Thomas. And in the course of those proceedings, what we found out is that Mr. Felt is the person, he is with Arizona Garage Builders. He measured the distance of the setback from Ms. Smith's wall, which would have been great if the wall followed the property line, but it didn't. And so that is how we ended up with building the apron of this garage and that concrete 7 feet into Ms. Smith's, or into the setback that's still on our property. Would you go to the next slide, please? Thank you. So I just want to talk about the statutory test for a minute. The topography of the lot, if you will look at it, it's outlined in blue there. It has a wash at the back and it's wider at the front than it is at the back. This is a peculiarity of that lot that allows you to find under the statutory test that this is the very best place for that garage to be. It really does create an undue hardship to have Mr. Thomas demolish this garage, which looks great. And, you know, it's really an unnecessary hardship because you still have 23 feet of setback there. The purpose of a setback is to separate buildings and structures from your neighbor. There's plenty of separation there. It looks great in the neighborhood, and he's had very good feedback from his neighbors that he hasn't done anything big and ugly and detached, which I'm going to show you what he could do in a moment. So it wouldn't look good to change it. And it's not a self-imposed hardship because I've just shown you that Mr. Thomas and Mrs. Thomas did not measure this themselves. They relied on a contractor. If you can't rely on that, I'm not sure how any building gets done. So owing to the peculiar conditions, a strict interpretation would work in a necessary hardship in this case. And granting the variance is in keeping with the letter and intent, the spirit and intent of the zoning code. If you would go to the next slide, please. And I will just show you what would be an option for Mr. Thomas and Mrs. Thomas to build. You see that graphic of a detached garage there? In the county, you can encroach all the way into the setback with a detached garage. So he could build that structure right there and it would look terrible, but that would be within the code's allowing. He could have saved it doing that. He could have saved 25% in his cash. He'd have more square footage, but he didn't want to do that because he did want it to fit nicely into the neighborhood. Last slide, please. Or he could have done this as well. He could have built it onto his house at a size that big. And, you know, I will just say that in Lone Mountain, that's done. But that's not what Mr. Thomas did. It's really nice looking. So would you go to the last slide? There's the as-built condition. Doesn't look like an afterthought. It belongs on that house, and it was a nightmare for the Thomases. But now they hope that they have a compatible thing. There's no neighborhood opposition, and we respectfully request that you grant the variance. Would you go to the last slide? Thanks. So thank you very much for your time and attention. Do you have any questions for me or for Mr. Thomas?
Thank you. Are there any questions from board members for the speaker? Member Person?
Question. Thank you. I'm just a little confused about who submitted the letter of opposition. Was that the Smiths and it's now been resolved, or was it someone else? And if so, can you just describe that for me?
Yes, it was Ms. Smith who had submitted a letter of opposition, before the last board meeting in October, and we requested a continuance. So here we are today. And on December 7th, she withdrew it and gave her consent.
Does that answer your question, Member Person?
It does.
All right. Anybody else who's available online have any questions? Member Schwartz.
Thank you for the presentation. So give me the timeline. Can you pull up the picture of the footings here? Of the footings that they were digging for the structure. Right there.
Right there.
Next one. Okay. So talk to me about the timeline again of when they discovered that the setback was off.
Well, it wasn't in connection with this discovery. They discovered that they were encroaching into onto her property early in the process, and they revised their garage plans and their plans to bring these utilities can't be run under the slab for the garage. So this was at the very beginning of the process in May or June of 2020. But this doesn't have to do with the mismeasuring of the setback. This just had to do with an error that occurred at the beginning of the process.
Right, but it all had to do with the fact that there was some sort of there was a dispute in where the property line was located. So my questions aren't suggesting that the Thomases did anything.
Thank you.
Okay,
Yes.
so I mean, I've been in the building business, but we've all had errors that have occurred
Sure,
with
it happens.
us. But I would have thought that at that time that the engineer and the surveyor, those are things that they have to put their stamp on and they have to verify. And it's odd that if there was already an error that was noticed in the field, the property line was off based upon what occurred there,
I see.
the same thing would have been resolved at the time. So that leads me to, have you had any conversations with the surveyor and with the engineer? Because those two, it sounds, and maybe, and if it's a design build, then it's all one.
Yes.
And so my question is to, have they been, at what point did they, obviously they did not address the whole property line issue because they were just addressing a utility issue, even though they knew that it was out. There was something wrong, the measurement was off. So,
If I can, I'd rather you hear that from Mr. Thomas himself. May I call him up to?
whatever the
question or-
protocol of the chair is. So,
Yeah, I do have a speaker request for Mr. Thomas, if you wanted to come up and speak. And I have to hand it to you for your email address, aquadude1971@gmail. I like that.
Thank you. I've been in the water treatment business most of my career, and somehow or another, many years ago, somebody called me an aquadude, and it's just stuck. So, good morning. My name is Mike Thomas. I'm the owner of the property in question. Mr. Board Member Schwartz, just to tell you what was going on here. The garage was already built. It was completed at this stage. And when we originally found out that there was an encroachment, the driveway had protruded onto the neighbor's lot by 34 it was maybe 40 inches. Don't quite remember the exact measurement, but we'll just call it 40 inches or 44 inches or something like that. And then it kind of went in a pie shape back about 11 feet, and that's what crossed the property line. So the builder had to remove that encroachment. It was also found out at that time that the utility lines were buried under the neighbor's property. So she wanted those moved as well, even though APS and Southwest Gas would allow for an easement. Yes, that was the term. She refused. That wasn't going to work. So the utility lines had to be moved because the utility lines previously went through my driveway, but in the new build, they would have been under the garage. So they had to move them. And when they moved them, they put them there. They later then tore up the driveway, the new driveway, and moved them onto my property. And then we removed the encroachment of the driveway that you can see in some of these pictures by, that amount of space.
So then I would have the order in reverse, that the garage is already completed.
Yes.
And the driveway was in, and then you determined there was a utility issue.
Exactly.
Okay, thank you. That helps.
I was
That's
literally
okay.
out sweeping the driveway for the first time, thinking the project was almost done. And then it really just began because of all this encroachment stuff, but it was removed. So.
Thank you very much. Are there any questions by any board members of the speaker, Mr. Thomas? All right, seeing none, this was the only speaker request card. Is there anyone in the audience who wishes to speak on this item? Is there anyone online? Mr. Anderson?
We're not aware of anyone online.
Okay, go ahead and close the public hearing. Hang tight, we may have more questions for either of you, and open it up for discussion and or a motion. This is in district number 2. I will real quick will reiterate something Member Schwartz said. Yes, sir. Yes.
Thank you, Mr. Chairman. As you know, the reason I'm here is to give legal advice. So something that Member Schwartz raised in an earlier question, I think needs to be addressed just so the board understands it. And I want you to understand that I don't believe the applicant was making an accusation. I just want to clear something up. Normally, as Mr. Schwartz indicated from his years of experience, plans that we receive will be sealed by an engineer and architect, someone who has the ability to seal a plan. When that happens, we are required by the seal to rely upon that plan. When we get plans that are unsealed, part of the application process is that the applicant swears that everything being submitted is true. We, as the regulator, do not have the legal obligation to verify that the plan is correct. When inspections are done, the obligation of the inspector is to ensure that the construction is being done in accordance with the plan. So if there's an error, it's not unusual that it would not be caught in the field. I believe a lot of our inspectors for setbacks will go and measure to confirm things, but that's not an obligation that we have. It's the obligation of whoever submits the plan to make sure that the plan is accurate. I'm not sure it affects this application at all, but Mr. Schwartz raised it more as a general question. I've been involved in litigation where the allegations have been made that it was the inspector's requirement to catch it, and the courts have universally ruled if you get a plan, you can rely on it. And part of it's practical. I mean, how are we going to have people go and check plans? So I just wanted so that the board understands that. Probably not in this case that it matters so much, but going forward.
Any questions of Mr. Peck? Thank you, Wayne. That was well stated and good for us to know. Again, just my 2 cents on this. I truly don't have an issue with it. I may have if there was still some disagreement with the neighbor, but that seems to have been resolved. As Member Schwartz said, all of us in one type of land development or another are just aware of a lot of mistakes that happen. It happens. So I don't have an issue with it, but I'll turn it over to other board members for any comments and or a motion. Again, this is District 2.
So let me just make some comments here. And that as I said in the last hearing, continue to struggle with the apathy of trying to resolve issues for people. And when, certain conditions arise. But at the same time, we have a mandate of finding these peculiar conditions as a means in which to either, as they apply or don't apply, to make a recommendation. I certainly, as I said, very sympathetic to this, but the engineer really dropped the ball on this particular issue because they should have, the first thing we rely on is our engineers to take a plot, and verify the boundary of a property and go out and do a field measurement before they start constructing. And the engineer didn't do that through the design. And then obviously, if he missed it in design, he missed it in the field. And the inspectors are only going to go off of the plans. So I'm back to my struggle. It's not that I don't want to help you, because in business, we want to find solutions. But that's not our preview here. So I'm not going to be in favor of it, not because I'm not sympathetic. I'm not going to be in favor of it because it doesn't meet the peculiar condition. But I'll leave it up to the rest of the board. I mean, I'm only one voice and one vote, but I'll leave it up to everybody else on how this proceeds.
Thank you, Member Schwartz. That you're okay with someone else making a motion in your district? All right, I'll turn it over to any board members. Anybody have comment or want to make a motion? Member Cardin.
Chairman Loper, thank you. My thoughts align, probably more in line with what you shared earlier. I in this case, would find a peculiar condition in the shape of the lot and would therefore make a motion that BA 2022053 be approved.
Have a motion for approval by Member Cardin. Is there a second?
Second.
A second by Member Ward. Rosalie, would you please do a roll call vote?
Member Cardin?
Yes.
Member Schwartz?
No.
Member Ward?
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 4-1.
Congratulations. Move on to the next agenda item, which is BA 2022-042, the Lofquist property, and turn it over to staff for presentation.
Thank you, Chairman and members of the board. Case BA 2022-042 is for the Lofquist property in Supervisor District 2. The site is located at 2727 North 76th Street in the Mesa area. The site is zoned R135 and is approximately 43,183 square feet. The owner is requesting a variance for the following request: a lot width of 118 feet, which is measured at the front yard setback, where 145 feet is the minimum permitted per Maricopa County Zoning Ordinance, Article 601.5.2. The variance for lot width is requested by the owner due to the building permit for the pool not being approved because the lot does not meet the minimum width requirements. The assessor records show the subject lot split from parent parcel 219-34009H to its current configuration with an area of 43,183 square feet and a lot width of 103 feet roughly at the county right-of-way, or 118 feet at the required front yard setback sometime in the year 2001, 3 years prior to the current owner obtaining the deed for the parcel. Assessor records also indicate the year of construction for the primary residence as early as 1959, which meets or exceeds the required setbacks. The site plan shown on screen illustrates dwelling as meeting or exceeding the setback requirements established per MCZO Article 601.4. The proposed pool also meets the required setback per Article 601.2.11.b. No other obstacles or site conditions prevent the pool from being constructed at the proposed location. If the lot had met the required lot width at exemption, this variance wouldn't be required for the pool permit. It is not possible to increase the lot's width by acquiring more area from the parcel to the south, as that is within a separate jurisdiction and zoning district. It may be possible to acquire area from the parcel to the north under separate private ownership while maintaining a minimum 145-foot width at the front yard setback for both parcels along the 76th Street frontage. Staff would like to note that they received a statement of support from a nearby property owner for the owner's request. Based upon what the applicant has submitted and the staff analysis in the report provided to the board, staff offers the following findings. The applicant has failed to demonstrate that there is a peculiar condition facing the property because a poorly executed lot split is not considered a peculiar condition, as this is self-imposed. The applicant has failed to demonstrate the peculiar condition physical hardship is not self-created in the line of title, in that the current condition of the lot is a direct result of an unregulated land division. The applicant has failed to demonstrate that the general intent and purpose of the zoning ordinance will be preserved with the variance, in that a granted variance for a poor lot splitting practice does not preserve the intent of the zoning ordinance intensity of use regulations, which in turn negatively impact yard regulations and required setbacks to surrounding properties. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state for the record the basis that determination with findings and conclusion in a motion to grant the relief sought. In such event, staff would offer the following to memorialize the variance approval. Variance approval establishes a minimum lot width of 118 feet for assessor parcel number 219-34009P. At this time, I'll be happy to answer any questions.
Thank you, Daniel. Great presentation. A question I have, and I'll turn it over to other board members of this, is you mentioned that there's not the ability to get more land is that the south? This is flipped on this exhibit, but they can't make it wider because the parcels are developed on either side, correct?
As for the south of the parcel, it's also under separate jurisdiction, but yes, it is developed. The parcel to the north remains vacant at this time, but however, it's under separate private ownership.
Okay, all right. Thank you. Any board members have any questions? Member Cardin?
Daniel, thank you. Does the current owner, did they do the lot split? Or did I understand you to say that it was after, that they purchased the property after the lot split?
Chairman and member, yes, that is correct. That they purchased the lot 3 years prior to the split.
3 years after, 3 years after the lot split.
Correct.
Thank you.
Member Person?
Daniel, what is the gray area on the site plan that you have on the screen? So there's an area outlined that's kind of shaded in gray.
Member Person, that is the shaded area on the site plan is representative of the covered driveway, I believe driveway surface material dust proof. So that would be the either ABC or equivalent.
Oh, okay, thank you.
Any other board member have any questions at this time? Thank you very much. Go ahead and open the public hearing. I have one speaker request card, which is the applicant, Stu Lofquist. Do you wish to speak? Please provide your name for the record and go ahead with your presentation.
Yes, my name is Stuart Lofquist. My wife and I are the owners of this property. I did purchase the property in 2004. My understanding, and I don't have any documentation to show this, I thought this property had been subdivided as far back as 1987. So, and I don't know if that's appropriate or germane to the conversation here. The way if you can look at the way the property is shaped, because I think the way the house was built, and then how many ever, I don't know if it originally was 5 or 10 or 20 acres, but because of the way the house was built, they shaped the property when it got subdivided so that we had the proper setbacks on the sides and on the back, and so I don't know if that developer only used like the square footage as their requirement and not, that 145 foot minimum dimension. But, this is kind of what we're stuck with. We haven't done any other development. We want to build a swimming pool with the notices and everything involved, besides one that you have on record. 2 of my neighbors stopped by when they saw the notification and asked what it was about. And when I explained, they said, "You have our support." And also another friend of ours from our church saw the notices. And again, when I explained about that, he says, "I don't have a problem with that." So unless somebody has a question for me, everything that's been submitted and what I was able to look at online appears to be correct.
Thank you very much. Do any board members have any questions of the speaker, who's also the applicant? All right, just hang tight. We may have some questions for you going forward. I open this up as a public hearing. Is there anyone in the audience who wishes to speak on this item? Seeing none. David, is there anyone online who wishes to speak?
We're not aware of anyone online.
All right, go ahead and close the public hearing and turn it over to the board members for discussion and or a motion. This is also in District 2.
I just go back to my previous comments that I made, so I don't just be redundant, that we have a sort of guidelines that we follow. And so again, I'm sympathetic to the issue, but I won't be in support of it. But I look towards the rest of the board to have their debate and discussion about it.
Thank you, Member Schwartz. My feeling on this is that until the county starts to regulate minor land divisions, this is going to happen. And this lot was, Daniel, what was the date this lot was created, we believe?
We believe that in the year 2001, from parent parcel 219340009H. That's what assessor records have.
So at least 20 years ago. and they have an existing residence on it and been living there unbeknownst to this. So, you know, it's one of those where I don't fault the property owner. I don't really consider it self-imposed either. So I'm in support of this particular variance, but I'll turn it over to other members for discussion. Member Cardin.
Chairman Loper, I appreciate the statutory test we have to do. To me, this one probably falls pretty squarely in the category of there's a human nature side of this, just that I don't know, the human element, the side of, I don't know how neatly it fits into the statutory test. I mean, in my mind, again, the shape of this parcel is absolutely a condition that the owner had no fault in and no awareness of, and I would move to approve BA 2022042.
We have a motion for approval by Member Cardin. Is there a second?
Second.
Second by Member Person. Before I call for the vote, I do have a question of staff. So in something like this, where it's, if the variance were not approved, what's next for the person who lives here, who's had this home for all this time?
Mr. Chairman, the only action would be that the county would withhold we would withhold any future permitting because it's unbuildable lot.
All right, thank you very much, Darren. All right, Rosalie, if you wouldn't mind taking roll call vote.
Member Cardin,
Yes.
Member Schwartz,
No.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes,
Chairman, that's an approval by a vote of 4-1.
congratulations. Mr. Peck, you have a comment?
Before you take the next matter, I would just like to clarify something. The county has no legal authority to regulate lot splits. The only thing the county can do is require certain paperwork. But even if the requested split does not meet the statute specifically prohibits the county from denying it. So you made the statement until the county regulates lot splits, there's no authority to do that. This could happen. There are counties, as you well know, that require you to submit certain paperwork. But even if this had been submitted in one of those counties, the county is powerless to deny the split, just as a point of clarification.
I definitely appreciate that. Thank you, Wayne. All right, move on to the next agenda item, number 4, BA 2022-047, the Cook Trujillo property. Turn it over to Daniel.
Thank you, Chairman and members of the board. Case BA 2022-047 is for the Cook Trujillo property in Supervisor District 4. The site is located at 16735 West Wildflower Drive in the Surprise area. The site is zoned Rural 43 and it's approximately 43,706 square feet. The applicant is requesting a variance with the following request. Swimming pool and incidental installations located within the lot's required front yard along the eastern property line. The applicant is requesting a variance to allow a pool to be constructed within the required front yard setback per Maricopa County Zoning Ordinance, Article 501.2.15.b, where pools are prohibited from being located within the required front yard. The site plan exhibit shown on the next slide is the site plan used for the pool permit, which shows the existing parcel condition. Although the home was built with the front oriented towards the north and the eastern and southern yards of the house fenced in with a block wall, the zoning ordinance defines the lot's front as the shortest side with access. An access easement is recorded along the outside of the eastern property line. Since this boundary is considered the front, a 40-foot front yard setback is required from the eastern property line. No accessory structures are permitted to be built within any required front yard setback. The applicant proposes the pool setback 23.5 feet from the eastern property line, along with incidental installations, the pool, aka pool equipment, within the front yard setback. The subject parcel was created via an unregulated lot split, a parent parcel APN 503-50029A in 2001. The site was originally platted as a portion of Lot 21 of the Dove Valley subdivision. The subject parcel is typical of the area and lot split development fashion with access to the property provided by privately recorded ingress-egress easements. The surrounding properties are accessed in a similar fashion. Access is not provided by county right-of-way. The residence was permitted in December of 2012. No other obstacles or site conditions prevent the pool from being constructed at any other location on the property. If the pool was proposed within a side yard or a rear yard, the variance wouldn't be required. Based upon what the applicant has submitted and the staff analysis in this report, staff offers the following findings. The applicant has failed to demonstrate that there is peculiar condition facing the property because no hindrances prevent the construction of the pool within other than the required front yard. The applicant has failed to demonstrate the strict application of the zoning ordinance to the applicant's property has caused undue physical hardship that prevents the development of the property. There are alternatives available to the property, such as redesigning the pool and existing pool barrier fencing to accommodate and avoid the front yard setback. Thus, this variance is not warranted. The applicant has failed to demonstrate the peculiar condition physical hardship is not self-created in the line of title and that the home's orientation on the lot does not define the front of the lot. And the applicant has failed to demonstrate that the general intent and purpose of the zoning ordinance will be preserved with the variance and that the intent of the zoning ordinance front yards requirements ensure an orderly appearance of residential uses from public rights of way, including private ingress-egress easements. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion in a motion to grant the relief sought. In such event, staff would offer the following to memorialize the variance approval. Variance approval establishes a pool and incidental installations located within the lot's required front yard along the eastern property line for APN 503-50029J. At this time, I'll be happy to answer any questions.
Thank you, Daniel. I have a question and I'll turn it over to other board members. So regardless of how the home faces northward, so they consider north to be their front yard, it's technically the east because there's the easement that connects it over to 167th Avenue.
Wildflower Avenue. So the east on the site plan shown on screen at the northeast corner of the
Okay.
You'll see that recorded.
See that now. And I should know this, but some places, and maybe it's a city versus a county thing, you can actually apply to have your home, the front designated a different direction. That's not an option in Maricopa County.
Not
or
in
even
the county.
in counties, as far as you know. Kind of looking at Wayne to see a nod either way.
I believe that's just address. I don't think you can apply to have the legal front change based on the zoning. That's basically what they're trying to do here.
Correct. But I didn't know if there was a process whereby you could go and have, say, I want the north side to be considered my front.
You can do that for addressing purposes in some jurisdictions, but it wouldn't change the zoning ordinance to do that.
Okay. All right. Thank you very much. Member Schwartz?
So Daniel, is there an option that the easement, the access easement on the frontage of this property could be abandoned and therefore this pool could then be built?
One of my concerns with doing that is that the legal recordation of the easement would affect other people who use that easement within the neighbor or within this lot split area. So that wasn't a consideration for me.
So no, my suggestion or my question is on their property only, not on how it impacts, not the entire easement, but the portion of the easement that is on their property that creates the condition of the setback.
I believe we can record a vehicular non-access easement along that on the western side of that property line that is recorded against the access easement, which would then make the lot orientation, or at least the definition by the zoning ordinance, the front of the lot as a north property line.
So then, and correct me if I'm wrong, then we in essence then by the county doing that recording that or the owner doing it in concert with the county, then they would need to come in front of us for a variance because then they'd be compliant, correct?
Correct.
Yep.
Mr. Chairman, I believe if they were going to start redesigning, they would have to somehow carry a easement along the north side a little ways, because the only place this specific easement touches their property is along the east lot line, because it comes in on it's on the east side of their lot. It's not on their lot. So it gets a little complicated. That would also, and then if they ran the easement along their north lot line, that would make the north the front, but that would impact setbacks and what the required front yard is as well. But I mean, it is doable.
Okay, so, but there is an option for us, for somebody, for them to sit down with you and their team to figure out if there is a option available that does not require them to come in front of us.
Certainly the easiest option would be to put the pool in the southwest quadrant of the yard, but yes.
Okay.
Any other questions, Member Cardin?
The option that was just being discussed, as I understood it, making it to where there was no vehicular access on the north side of the home, wouldn't that mean they could never get to their garage?
On the east side.
Mr. Chairman, Member Cardin, I believe the idea was one of the options could be to put a vehicular non-access easement along the east, so that's not considered the front. But I think in order to do that, you need to extend the easement along the north.
Got it. Okay. Thank you.
Any other questions by members of staff? A follow-up to this that I have, is there a minimum, if they did the V&E along the east at that northeast corner, they'd have to have some kind of little key or something coming out there, as you mentioned, to give them legal access. Is there a minimum width?
Mr. Chairman, there's nothing codified in the ordinance, but as a rule of thumb, I've always said it needs to be at least the length of the easement width. That makes sense. So it is at least as far along the north as it protrudes down the east. Does that make sense?
It does. And there's really no way from this to tell if that impacts the front setback or then the rear setback or others. We might be, I like the idea a lot, but I don't know if it creates other issues.
So, Mr. Chairman, so for a Rule 43 lot, you would have a 40-foot, you would then require 40 feet along the north, but that would bump out a little further in the northeast because of the presence of the easement. But where the easement ends, they would have a little bit of room. I don't know without seeing that illustrated on the plan. And I can't go off the site plan in front of me because it's been reduced.
Understood. Thank you. Any other questions of staff at this time? Is the applicant or applicant's representative in attendance today? And wishing to speak, I don't have a speaker request card, but if there's someone here to speak on the applicant's behalf, could you please raise your hand if you're in the audience?
He's not here.
Not here?
No.
Is he online?
No.
Do we have anyone else online that wishes to speak on this item?
We're not aware of anyone online.
Okay, I'm going to go ahead and close the public hearing. This is in my district, and I am curious, maybe there are options, and there may not be after you get into the site plan details, but I'm inclined, I'll just throw this out here, I'm inclined to continue this to give the applicant time to discuss with the county on options. And if they don't have to come back to us, they don't. If they do, we could hear this particular variance, or if there are others that would have to be lumped in it or in different variances they need, we could address it at that time. So with that, I'm going, Member Person, you have a question?
Just a statement. I hear what you're saying about the continuance. I personally feel that when we have these cases where there's a difference in the front yard interpretation, I personally consider that a peculiar condition. So, I would be in favor of moving this forward and letting them proceed, but I'll wait to hear what the rest of the board thinks.
Okay, thank you. Member Cardin.
So, boy, Member Person was just persuasive to me there. I'll also, to add a little more, make it a little more muddy. I'm going off of a distant memory, but when we reviewed our I don't know what our charter is or bylaws or whatever that controls this board, if the applicant isn't here, wasn't there some suggestion that we were supposed to continue regardless? Or maybe I'm remembering wrong. But anyway, having said that, I'm even comfortable with Member Person's, Vice Chair Person's interpretation.
Darren, is there anything in our bylaws about that? I know it's been a practice, but I didn't.
Mr. Chairman, we're opening the bylaws right now. I do believe that is the case.
I see the dust.
As a great public servant, I did not bring a copy of the bylaws with me, but Rachel, of course, is on it.
Not surprisingly, none of us have it either.
It's a reminder for me to keep a copy in my BOA pack. I do appreciate the fact that you recognize we have bylaws for the BOA.
Which I think all had to sign that we had read and agreed to. Well, that's being discussed. Well, I guess we need to know if we could take an action other than continuance.
After Vice Chair Person's comment, I should have just stayed quiet.
That's good to know.
Mr. Chairman, board members, on page 4 of 8, item O, says that the initial hearing for an application, no action will be considered other than continuation unless there's a personal appearance at the hearing by the applicant or a designated representative, or the item is on the consent agenda.
All right, looks like our hands are tied. Thank you. Thank you for looking that up. All right, then I would move that we continue this to the next hearing of the Maricopa County Board of Adjustment, whatever date that is. That's my motion, is move it to the next hearing. Give them opportunity to work with staff and certainly appear so we can at least make some discussion. Sorry, Member Person, you were kind of getting me going that way too.
No, that's okay. I'll second your motion. We got to follow the rules, and it's too bad for them they didn't show up.
There you go. So it'd be January 19th. I've made a motion. Is there a second?
Mr. Chairman.
Oh, I just seconded.
Bylaws say it needs a motion.
There should be no action.
Can't take an action. The bylaws say if the applicant doesn't appear, then you can't take any action but continue. Doing a motion is an action. My opinion would be it's just continued as a matter of requirement of the bylaws, and you would just announce the date so that new notices would be required.
Okay, then this case is.
Vote no on the motion.
There you go. Where have I heard that before? All right, with that stated, then this item is automatically continued to the January 19th, 2023 Maricopa County Board of Adjustment hearing. And we'll move on to the next item, item number 5, which was continued. So it's item number 6, which is the TU 2021-043, the Olson property. And I'll turn this over to Joe Mueller. Well, Joe?
Thank you, Chairman, members of the board. Case TU 2021-043 is for the Olson property in Supervisor District 3. Next slide, please. Site is located at 427 East Courtsrack Road in the Phoenix area in the Rural 43 zoning district and is approximately 1 acre. Next slide, please. The request is to allow temporary dwelling in a camper trailer for 2 years during home construction. The property has active violation V 2021-02297 for dwelling in a camper trailer. Approval of the request would resolve the violation and allow continuation of the occupied trailer as long as the house permit B 2021-11271 is active or until the expiration of the timeframe granted by the board. The request has received 2 letters of opposition. Staff has found that the issuance of a permit for a single-family residence on the site, the applicant meets the ordinance requirements for temporary housing on site during home construction. However, staff feels that with combined evidence from opposition emails, as well as from code enforcement documentation, it is clear that the applicant has already been residing on the property in the camper trailer for well over a year. As such, staff feels that a time frame of 1 year rather than the requested 2 years is appropriate. Staff recommends approval of TU 2021-043 on APN 210-14039B for 1 year, subject to conditions A through J. At this time, I would be happy to answer any questions.
Thank you, Joe. Great presentation. Are there any questions of staff at this time? All right, go ahead and open the public hearing. Is the applicant or applicant's representative available? I do have a card for Robert Olson.
Yes, I'm here. So,
Mr. Olson, will you give your name for the record, please, and then go ahead.
sure. My name is Robert Olson. I go by Bob Olson. So we did apply for the building permit B2021-11271. And then when we were told that we needed an occupation permit, we applied for TU 2021-1043. And then we weren't staying in the trailer after May, so I have a receipt that shows I stayed in a Airbnb from May through September, and then I also have a place in Mexico that I stay, and I've been renting in Drury Inn, and I've also stayed with my friend Maria, and so I have a signed letter saying from my friend Maria saying, you know, that she believes that that's true. Also, the letter of opposition that we got said that there was trash on the property, but I have trash service, and so I have receipts that show I have, you know, trash service on the property. Plus, I wasn't staying on the property, you know, after May. So it's hard to believe that if I wasn't staying at the property, I would go to the property and leave trash there, especially since I had, you know, trash service. And the other thing is, on the letter of application, they said I lied as far as the reason of staying on the property. And so I'd spoken to the neighbor, Ernesto, and he had told me about building materials that had been stolen from other lots. And so that's what I put in my application. And so I have a signed letter from Ernesto saying, you know, that's what he had stated to me. So I can show that I wasn't living on the lot, and I can show that the information in the letter of opposition is not true. Like, for example, in the letter of opposition, it said there were motor oil containers on the lot. Well, I drive an electric car, so I would not have motor oil containers on my lot. So I can prove pretty much everything in the letter of opposition is not true.
Mr. Olson, today before us is the request for the temporary use permit to use the RV while your home's being constructed. The other items that you're mentioning really are not part of that discussion directly for us.
Sure, it's just that there was a letter of opposition.
No, I definitely understand that.
So that the information in the letter of opposition is not true?
Mr. Chairman, if I could, quick discussion with council. Since he's asked for 2 years and we're recommending 1, some of those issues do speak to whether it's appropriate for ongoing residency. So, hear him out.
Mr. Olson, did you want to continue within the next 30 seconds?
No, that's fine.
So staff's recommendation is that the temporary use permit be limited to a year. Is that sufficient time to finish the home, the residence? It is. And then a question for Joe or Darren or Rachel or someone. If at the end of the year, is he eligible to apply again? Let's say he needs another few months, or is it just once?
Chairman, he is eligible for 1 extension that would have to come to the board for approval.
Okay, thank you very much. Hold on, I think some people have some questions. Member Schwartz?
So you're not currently living in the RV and haven't been in the past, is that correct?
We moved it off the property
So it's not even on the property right now?
right now. Because my builder said he was ready to go and he wanted it out of the way so he could do the grading and the builder said that after the grading and the slab is in place, then it could be moved back. So yes, the trailer is not on the property right now.
Okay, so, and you have other places to stay
Yes,
currently, correct?
yes.
So what would prohibit you from extending your stay somewhere else rather than trying to pull the trailer back on here temporarily for a short period of time if the slab the slab is not done yet, correct?
Correct. Yeah, it's just a couple of things. I mean, one is, per our neighbor's advice, that he recommended somebody being on site, to make sure that building materials didn't disappear. And then the other thing is, there was a violation that we got, and what we were told in the violation is we just needed to, get the temporary user permit to, clear up the violation.
Have you looked at other ways of securing construction supplies on the lot, like fencing and putting a remote camera on there like all the rest of our construction projects have, so you can remotely monitor what's going on?
Sure, I'm sure there's other options. It's just that I thought that I had to, get this permit cleared up so that I could clear the violation, that I had initially put it on the lot without, the user permit. So I just wanted to clear that up.
Yeah, but so you've cleared the violation up now because you no longer have the RV on site. So the violation's been cured. Is that correct? Of staff?
Mr. Chairman, board members, I don't know the current status of the violation. I will, if you provide the photographic evidence of the site condition, I can have the case administratively closed.
Okay.
So I guess my point is that I'm questioning whether you really feel the necessity to pull the trailer back on to the lot, because there may be other options, and the fact that now the violation to be confirmed has been cleared. Is that correct?
Yeah, that's correct.
So, okay, so that's all I have.
Any other board members have any questions of the applicant? Right, go ahead and have a seat. Stay close. We may have more questions. Is there anyone in the audience who wishes to speak on this item? Seeing no raised hands, is there anyone online who wishes to speak on this item?
We're not aware of anyone online.
Thank you, David. I'll go ahead and close the public hearing. And this is in District 3, but before I open it up for a motion, I do have a comment on it. I personally would want to be on my own property to guard my materials. That's me. And I just, as you know, I just finished working for a home builder, and I can tell you the cameras gave a false sense of security because it was like an open door on a lumber yard, the amount of stuff that would be stolen from an active subdivision, let alone from a residence. So I'm supporting the temporary use permit at a year. That's just me on one voice. But with that, I'll turn it over to other board members for discussion and or motion. Again, this is in District 3. Yeah, Member Schwartz.
So I understand the comparison that you're trying to place, but this is a little different than a subdivision with single family lots where it's hard to put all of your lumber and materials are just individually scattered on whatever lot has been released to construct. In this case, it's one lot, it's one place for material. And so we've seen, development sites all around Maricopa County that are enclosed properties, and they have enclosed, areas that they've secured for those materials. I just feel that after hearing from the applicant, he has no need really for the special use permit. So there's no reason for us to act on it because he just clearly wants to make sure at this point that the violation's been closed and has other places in which, another place in which to reside while construction is going on. So if there is no necessity for us to act, then why act?
Thank you, Member Schwartz. And I definitely appreciate that position. I feel like he's applied for the permit, and this is normally just an administrative process, but for the complaints and the violation on it. And he may change his mind and want to move there. And I feel it's appropriate personally for the temporary use permit. So again, I'm in favor of it, but we'll turn it over to anybody else who has questions, comments, and or wants to make a motion either way on this. Member
Chairman
Brisson.
Loper.
Yes.
Yeah, I agree with you. I've actually had things stolen out of a fully locked up home while it was under construction, a bunch of appliances and stuff. So I can appreciate it. I know it's not in our purview if there are additional complaints and there are code enforcement options for that, but I would move that we approve case TU 2021-043 for the 1 year period subject to the language outlined in the staff report.
Thank you, Member Person, for the motion. Is there a second?
Second.
Member Cardin? Member Cardin seconded. Rosalie, would you please take a roll call vote?
Member Cardin?
Yes.
Member Schwartz?
No.
Member Ward?
Yes.
Vice Chairperson?
Yes.
Chairman Loper?
Yes.
Chairman, that's an approval by a vote of 4-1.
Congratulations. Move on to the next item on the agenda, item number TU 2022-037, the Jimenez property in District 5. 4 or 5? I think that was an error on the, yeah.
Mr. Chairman, before we get the staff presentation, I don't know if the applicant, I'm sorry, I'm speaking about the next case, never mind.
Okay. Go ahead, Nick.
Thank you, Chairman Loper and members of the board. Case TU 2022-037 is a request for a temporary use permit for temporary housing on the Jimenez property at 11748 South 45th Avenue. Next slide, please. So the subject site is zoned rural 43 and is located in the Levine area near 43rd Avenue and Estrella Drive at parcel 300-77014G. The parcel is approximately 1.1 acres and was recently vacant, though a building permit has been issued for a single-family residence and is currently active. While their permanent home is under construction, the property owners are requesting to use their 27-foot by 7-foot 10-inch travel trailer as a temporary residence. Staff received one letter of opposition from neighboring homeowners who attest that there have been many other new homes built in the area without the need for temporary housing. In their letter, they reference an ongoing code violation on the subject property and further attest that the applicants have been living in their trailer on and off since as early as February 2022. Nonetheless, staff believes that the applicant has satisfied the requirements of MCZO Article 1302.2.1 regarding temporary housing, and furthermore, approval would resolve one of the charges levied against the applicants as part of the violation. As such, staff recommends approval of the TUP subject to the conditions of approval outlined in paragraph 22 of the staff report. At this time, I would be happy to answer any questions.
Thank you, Nick. Great presentation. Are there any questions of staff at this point from any board member? Seeing none, open the public hearing. Is the applicant or their representative here today and wish to speak on this item? Oh, if you could come on up and provide your name for the record and then tell us your request for a temporary use permit.
All right, so my name's Angelica Dominguez, and this is my mom, Angelica Jimenez. She is requesting the work permit, for the trailer to be on the site, as you know, for the whole process of the house being built. We started everything. They're doing the, let me look at that name, sorry. The field density test protocol, and they, the floor plans and everything, it's approved. ¿Qué más tienes que decir? O dime algo que tienes que decir. We want the permit because when the land was vacant, people living in the back, and I'm pretty sure people living in the side of the land, use that as a just like a road. So they crossed and they made their own roads everywhere. When we got there, we got people where they used to just bring their cars or stolen cars and just leave them there and then like set them on fire. That happened to the neighbor in front of us. And so my mom and my dad have their material there for building their house. They want to take care of it. They want to be present when the process is there. I guess the letter said that they were living on and off of in the trailer. I took them to my house because it was really cold. So they lived with me for a little bit, and then they came back because they want to make sure that, you know, their stuff's still there, and they just want to be present when their house is being built. Pretty, I mean, for me, it's pretty simple, but I don't know. Also, I don't know where the lot, I'm guessing, because we're gonna start building the fence in the back. And so I don't know if there's any problems with that. I don't know if I have to get a permit, but the permits and everything for building their house, it's good to go. So this will settle everything and we can move forward because it's costing us money as well. So. ¿Algo más que tengas que decir?
Que vamos a empezar a hacer la barra por el problema que tenemos.
Guessing that's it.
Thank you. Thank you very much. Are there any questions of, yes, Darren?
Mr. Chairman, just for the applicant's knowledge, if the fence was not included in the permit for constructing the house, there's a separate permit.
It's included.
Okay.
I know that probably the person that it's doing the opposition letter is going to have a problem with that, but the fence, it's approved.
So if it's, yes, so if the fence is part of the project description of the permit and shown on the site plan, then since that, if the house permit is issued, that includes the fence.
So we can start building it. Okay.
Thank you. Are there any questions of the applicant by board member? Member Schwartz?
Well, this is more for staff, I think, than the applicant. So how do we ensure that when an application like this comes forward, that when we want to help and grant them this special use permit, that people aren't just going through a design process, pulling a permit, putting out their trailer out there, and then 2 years later, nothing's been done. I'm not suggesting that that's what we're going to do. I'm just wondering what kind of fail-safe do we have in place so we don't find ourselves with a lot of mobile homes just being dropped on lots.
So, Mr. Chairman, board member Schwartz, quickly, if since this can be administratively approved, and it would be administratively approved as a matter of course, but for opposition, that's why it was brought here before you. The permit is not any temporary use permit approval is contingent upon there being an issued construction permit for the house. So they will have had to gone through all the permitting process. So there's expense involved. And then it becomes invalid, temporary use permit becomes invalidated if the single family residence permit expires. So if they don't pass an inspection within 6 months, the permit expires. There's a process for renewing the permit, but then again, the conditions of the temporary use permit are limited to either the 1 year or the 2 year, or the filing of the house, meaning the certificate of occupancy, whichever occurs first.
Thank you.
Thank you. Any other board members have any questions? May have lost member person. All right. Thank you. Hang tight. We may have other questions for you. This is a public hearing. Is there anyone in the audience who wishes to speak on this item? Yes, sir.
I turned the card in. Did you get it? Put your glasses on.
Yeah. Roy Krugel. Thank you very much. Had that as the next item. So thank you for clarifying that. If you could come up to the podium and provide your name for the record, and then says you're in opposition, go ahead with your.
My name is Roy Kriegel. I live adjacent to the property in question. There's several things. Number one, the RV was moved in about February of last year. So it's been there almost 10 months already. And they've been living in and out of it constantly. There's no sign of sewage septic system taken care of. There's no power, there's no water, there's no amenities. I looked at the gentleman behind me and he had a trailer, and I seen a big tank for water. I seen propane, I seen electric box. There's nothing like it in there. It's just, they're just bringing it in and all kinds of stuff in there. So it's collecting junk already. And the applicant put down that junk car's been there. I've been out there 40 years and I've never seen a junk car dumped over there yet. Now, the people at the end down there, they do come across other people's, but I don't see anybody coming across this. They talk about putting up a fence. That's a watershed. And I've been in contact with Maricopa County watershed people, and they said they won't allow a fence to go in there to inhibit the water. I could show you pictures of the water running knee deep, 30 feet wide, going down that street, going right through this property and out into the next one. So, and furthermore, the address given is false, because it can't be, they have to go off of 45th Drive, not 45th Avenue, because 45th Avenue does not exist. There's an easement off of my property going back solely for the purpose of supplying to the two houses behind me. But 45th Avenue per se does not exist. On the south side, SRP has got their head gate blocking. You couldn't, SRP ain't gonna move their head gate unless it's an act of Congress. And on the north side, the same way, there's head gates in there. So 45th Avenue, as far as I can see, being an engineer, that's not gonna work. So they have to change that. And that's just a change in clerical to go off 45th Drive, because that's what it was set up as when this 20-acre parcel was divided. But I don't want to see this trailer moved in, because they're already been violating the laws. They don't have all the proper septic, water, power, sewer, all that good stuff that they need to have It's in there. Now, last weekend, they moved the trailer from on the easement, like, or the setback was not even close to being, so they moved the trailer off to the side. So that if somebody came out from the county, they could say, oh, we guys off to the side. But it's really not, it wasn't off to the side as of a week ago. So anyway, myself and a bunch of our neighbors are opposed to grant them a variance to put the trailer on because of, first off, Maricopa County has too many people to enforce the codes. So if we would grant it to them, what's to say a year ago, they've already been there, the trailer's been there at least 10 months. So what's to stop them from staying there after the 12-month variance? Any questions?
Any questions of the speaker? Not at this time. We may, so come back, but I do have a question or just clarification from staff. The septic, the electric green tag to get the electric, that's part of the building permit for the home that they are in process of receiving or have received, correct?
Mr. Chairman, that is correct.
Okay, so those items they don't have would be coming in as the home is being constructed. And the same for any review of a fence, if it's obstructing a waterway, drainage review, flood control district would be looking at that as well.
So who takes care of that? If I see a problem going on, who do I talk to?
Mr. Chairman, I can give, I can provide my contact information, so you can always email me. But during the construction process, it's likely to be a civil matter if there's any damage caused by inundation that results from the construction.
Did you catch that, sir? You can get his card.
What I got was it's a civil matter and that the county enforcement is not going to do anything about it.
Mr. Chairman, if a permit is issued, it means that the plans meet requirements, and inspections will ensure that it's built according to the plans that meets requirements. But during the process of construction, it will become a civil matter. If there was not a permit issued, there could be a violation for anything that occurs, such as on permanent construction. But once that permit is issued, any enforcement is held in abeyance, and it becomes a matter of construction safety inspections. But there's a time period during that construction that it's going to become a civil matter if something occurs during that period.
Does that clarify it a little bit more for you?
But I'm concerned about the amount of water that comes off of South Mountain, off of Carver Hill, and down in there, flows down Cayupoco, which is the road that leads into this property. It dead ends there, and the amount of water is just tremendous. And we've given a whole video to the county flood control people.
Go ahead,
Mr. Chairman. Not to belabor, but post-development condition will maintain historic flows. So it'll maintain the historic condition or improve upon it, but it will not adversely increase.
I don't understand what he said.
So when you construct a project, this is anywhere in America, anywhere,
for example, or
pardon?
You construct a project, putting up a house is a project.
Putting up a house, right?
Okay.
You're not allowed to restrict waterways. The amount of water that enters that property and the amount that exits the property need to be the same post-construction as they were pre-construction. That includes the discharge point, the point where it leaves the property, and the volume, the amount of water. I would encourage you, maybe get Darren's card. It's probably somebody in drainage review that'd be more helpful to you on it, but you could start with Darren, and he could get you to the right person to talk about drainage issues in that area.
What has us nervous is if they put a block wall across there, the amount of hundreds of thousands of gallons of water is going to flood out my property and three other properties.
I would imagine that the wall type location, whether it has allowances for drainage, has been or is being reviewed. So again, I would encourage you to talk to Darren about that.
Thank you.
Thank you. Any other questions or comments of the speaker? All right, this is a public hearing. Is there anyone else in attendance that wishes to speak on this item? Not seeing anybody in person. Is there anybody online?
We're not aware of anyone online.
Right. I'm aware the applicant would like a rebuttal. Ma'am, did you want to rebut? I could give you 1 minute. If you have to come up to the podium, please.
So he says that the water tank, my dad has horses on, he rents a place where he keeps his horses. So the water that he sees that he brings in, it's to take them to the place where the horses are. And then for the water, the fence, the way, because we don't care if the water goes into our property, because the house is going to be, well, her property. The house is going to be elevated where it's not going to affect us at all. In fact, like they're going to put grass so that water is going to help when it comes down. So the fence that they did, it's a brick wall, and then it has a drainage access.
Weep holes.
Yeah, at the bottom. And then from what we see, that's not a wash or anything that was there before. It was people that, carried or wanted to clear their dirt, and they made it into like a little canal. So now it's there, which we don't mind it. I mean, the water, it's not a problem with us. So the fence shouldn't affect them at all. And then for the utilities, they have solar panels in the property. And then they have a, I don't know what you call it, for the septic. They have like a roller, a temporary for an RV kind of thing. And the water, we have a little tank that we use and everything, but we're waiting because this is slowing us the process of everything. So we can't move forward with SRP or anything unless we resolve this issue. We are in contact with SRP, they're waiting on us, and then we have for the water as well. So they're waiting on us to fix the matter as well. And then the house is being built. So we started, so the house is gonna be built maybe less than a year. That's why we just want a year, and then we'll move that out of there. So.
Okay. All right. Thank you very much.
Thank you.
Any further questions of the applicant by anybody? If not, I'll go ahead and close the public hearing. This is in District 5. Is that what I'm showing?
I can confirm that this is in District 5.
District 5. I'll turn it over to board members for discussion and or a motion.
I have a question, please.
Go ahead, Fern.
Thank you. I think this is to Darren. I'm not sure, but in Mr. Kriegel's letter, he stated that the easement isn't on 45th Avenue, but on his property. Is that anything we need to be aware or discuss, or is?
Mr. Chairman, Member Ward, it is not. This is a through lot with easements or dedicated right of way, either one on both sides. It's a non-issue for this.
Ancillary question to that, part of the permitting process is to verify, confirm, or correct an address, to provide the correct address, whatever that is.
Mr. Chairman, that is correct. There will either be an address assignment for the first time or address verification with every permit that comes through. Although it probably is appropriate for it to be addressed off 45th Drive, considering the site plan shows the driveway on that side and the only driveway on that side. So that's a non-issue.
Okay. Member Ward, does that answer your question? Okay.
Yes.
All right. Any other discussion items or motion for board member?
I apologize in advance for my dogs barking in the background. But unless there's any other discussion, I would like to make a motion that we approve this with the recommendations suggested by staff.
We have a motion for approval by Member Ward. Is there a second?
Second.
Second by Member Schwartz. Would you please take a roll call vote?
Member Carter,
Yes.
Member Schwartz,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 5-0.
Mr. Chairman, if I could, the next item is agenda item 8, TU 2022-060, a concert event in District 4 with the, I'm sorry, it's either 4 or 5, but it's District 4 listed by Luis Gonitas. And we administratively denied this temporary use permit because we never had materials provided that gave us sufficient warrant for approval of a very large concert/party event in a very isolated location. The sheriff's office had concerns, which is the chief reason for our denial. We scheduled this because as a normal course of procedure, if we do not approve administratively a temporary use permit, we'll schedule it for the Board of Adjustment. The thought was this event was proposed for December 10th. The thought was perhaps they would modify their request and for a later date, and we could even have materials that are in approvable form. That never occurred. I don't know. I assume the event occurred, but I do not know. It was administratively denied. We have received no citizen complaints, and we haven't received any report from the sheriff's office of an incident response. Although we're recommending denial and you could act on it, I think it's largely a moot point because the request, unless the applicants here are online, the request was for an event on December 10th, and that date is passed.
It's gone by. I'll ask our IT team, David, is there anybody online representing the concert event in Tonopah by Luis Godinez?
We're not aware of anyone online who
And
has
I don't
expressed
believe we have
interest.
anybody in attendance. So in this, do we just let it die? Do we continue it?
Mr. Chairman, I believe you can just let it die,
Okay,
and we will administratively close this case.
all right. And that brings us to the last item on the agenda, which was BA 2022-036. I need to recuse myself from this item. And Member Person, you are the vice chair, but in discussing this with staff, they thought it better that somebody in attendance should run this. So I'll be handing that over to Member Schwartz and his capable hands. Thank you all. It is this item right here.
Thank you, Chairman Loper. Let's give him a chance to leave, and then we can start with the staff presentation.
Thank you.
Okay, staff, if you can start with the presentation, thank you.
Thank you, Chairman. Members of the board, case BA 2022036 is for the Weiss Family Trust property in Supervisor District 2. The site is located at 948 North Chrisman Place in the Mesa area. The site is zoned Rural 43 and is approximately 1.43 acres. The applicant is requesting a variance of the associated split of assessor parcel number 220-20023J with the following request: a lot size of 21,776 square feet, where 43,560 square feet is the minimum required. For lot number 1, a lot width to be 142 feet, where 145 feet is the minimum lot width required for lot 1. A front yard setback of 11 feet to accommodate the existing dwelling unit on lot 1, where 40 feet is required. A side yard setback of 3 feet to accommodate the existing dwelling unit on lot 1, where 30 feet is required. A lot size of 40,419 square feet, where 43,560 square feet is required for lot 2. A side yard setback of 22 feet to accommodate the existing dwelling unit on lot 2, where 30 feet is required. If you go to Exhibit C here, shown here on screen, This is a historic county aerial photography of the lot as it existed prior to the adoption of the zoning ordinance. Once the two lots had been consolidated by the owners on February 26, 1997 into the current assessor parcel number, or APN, any potential legal nonconforming condition to the site was lost as the new APN allowed the lots to conform to the Rule 43 zoning standards. The lot combination was not a result of a county variance for the adjacent RAS property approved on November 9, 2005, as presented by the applicant. The applicant has also provided similarly sized lots on the next exhibit in the surrounding neighborhood where minimum lot sizes are met per zoning standards on the next slide. Thank you. But without further research, staff was unable to determine whether these lots were created prior to the adoption of the zoning ordinance and subject to legal nonconforming condition. Staff received 4 letters in opposition to the request from area landowners. The letters of opposition have been published with the report. The letters of opposition center on protecting the integrity of the zoning ordinance and the increase in density and traffic potentially caused by the additional lot where 2 more dwelling units would be allowed, a primary residence and the secondary dwelling unit allowed under the current zoning. Based upon what the applicant has submitted, further with the exhibits provided by the applicant in the handout report provided to the board this morning, staff finds that the request still does not meet the statutory test for variance approval. The applicant has failed to demonstrate that there is a peculiar condition facing the property, because the proposed modification would be self-created with the processing on a regulated land division to create 2 non-conforming Rural 43 lots. The will to deed land to children is not a peculiar condition facing the property. The applicant has failed to demonstrate that the strict application of the zoning ordinance to the applicant's property has caused undue physical hardship that prevents the development of the property. The property is already developed with multiple structures. It is not possible to split the property into 2 separate parcels that comply with Rural 43 lot area and lot width requirements. The applicant has failed to demonstrate the peculiar condition. Physical hardship is not self-created in the line of title. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination, with findings and conclusion in the motion to grant the relief sought. In such event, staff would offer the following to memorialize the variance approval. Variance approval establishes a lot size of 21,776 square feet for lot 1, associated with split of APN 220200023J. Variance approval establishes a lot size of 40,419 square feet for lot 2, associated with the split of the subject APN. Variance approval establishes a lot width of 142 feet for lot 1 associated with the split of the subject APN. Variance approval establishes a front yard north setback of 11 feet for lot 1 associated with the lot split of the subject APN. Variance approval establishes a side yard east setback of 3 feet for lot 1 associated with the split of the subject APN. Variance approval establishes a side yard north setback of 22 feet for lot 2 associated with the split of the subject APN. At this time, I'll be happy to answer any questions.
Thank you, Daniel. Board members, does anybody have any questions of staff? Okay, can we ask the applicant's representative to come up? Please state your name for the record.
Good morning, Chairman Schwartz and members of the board. My name is Shane Allman with Tiffany and Bosco, 2525 East Camelback Road, Phoenix, Arizona. I also have Mr. Wise, who represents the Wise family, who's owned the property since the 1960s. And so I've got some slides. If you could go ahead and move to the number 1 slide. I put some numbers at the top right corner just to help us as we move through some of this information. So there's been a lot of history. As you can imagine, the Wise family has owned this property since the 1960s. And there has been some shifts as far as the lot lines and how the lots have been configured on this property. But overall, the property has been owned by the Wise family as an L-shaped property. And an L-shaped property, of course, as you can imagine, makes it difficult to develop in certain respects. And one of the things that we do look at, I don't know if you can see it very clearly on this aerial before you, is that this is the only property that the Wise owning this property as an L shape is the only property that's shaped like this. Most of them are very rectangular. in shape as you normally see in an R43 zoning area. The only one that I would say is different is the one that's directly adjacent to us, right on the hard corner. And if we move to the next slide, slide 2, you can kind of see that configuration a little bit better with those layout of R43. You go to slide 3. And then you can see that hard corner. So that hard corner is about 18,000 square feet in size. It is R43 as well, just like we are. And they actually had a variance that was approved to solidify that shape and solidify that square footage on that site probably about 10 years ago or so. I might be a little off on that, but that was approved by the Board of Adjustment back then to configure that property as an 18,000 square foot lot. And also, as you can see, that property is right next to the property line. There were a number of variances that were approved at the time for setbacks. So what that did for the Wise property is it solidified this site, and basically it was recognized by the county as an 18,000 square foot lot. So that solidified the development pattern that we now have, leaving the Wise family as an L-shaped property for the near future. The impetus for this variance, the reason why we're bringing this forth, is about a year ago, the matriarch of the Wise family passed away. And as part of her wishes, now, of course, what can be done legally and what someone has in their will, she wanted that to be the property to be given to the next generation, their families. There's three family members part of that. So we originally came in with, hey, we'd like to be able to split this as 3 lots. We recognized that was probably overkill, too much. And so we have scaled back that request. And what we're requesting today is to allow for the lot on the top to be the same size as what we call the Rast property. That's who owns that, right on the hard corner. So it's about the same size in square footage. And then that leaves the parcel on the south as a rectangular shape, which is similar to the development patterns that's around there. And it's just shy of 43,500 square feet. And so that's what we're asking today. So in terms of, if we could go to the next slide, next one, number 5. So in terms of the peculiar conditions of this just kind of summarized what I just laid out, is that this property has been an L-shaped, or the Wise's property has been owned as an L-shaped area since the 1960s. That Rast property has always been an about 16,000 square foot lot. And with the variance approval to the Rast, it further solidified the development pattern and the configurations in the area. So there's no other configuration in the area, like I said, that's similar to this. And so the granting of the proposed variances recognizes these conditions that are peculiar in the area, and allow for a more uniform residential development for us going forward and following that development pattern that's been established on this hard corner since the 1960s. So if we go to the next slide, this is just kind of the historical layout. The Wise own it. This is the oldest one I could get that showed the buildings in 1976. So you can see the buildings that were put on there. If you go to slide number 7, this is year 2000. That's important because, of course, we get into legal non-conforming status in the zoning ordinance. And those 3 buildings were established at year 2000. And so some of the variances that we're seeking is to recognize those buildings that are there, and staff recommended or asked us to be able to include some setback variances to allow for those buildings to stay there now that we've created those lot lines. So if we go to the next slide, we can keep going. So this is a necessary hardship test number 2. Again, I think I've talked about that. But this just, it does create a development situation that's difficult, developing with an L shape. So it's trying to establish the lot so that it's similar to what's been established by the Rast property on the hard corner with the variance, and to be able to allow that to develop with the next generation in a more uniform manner. Next slide. Yeah, this is just reiterating what I've done. So number 11, go to the next slide. So no negative impacts. We don't believe that there's going to be any impacts. We're not asking for anything that's smaller than the Rast property. So in fact, we're a little bit larger than that property. The next slide will show you that there's been a number of parcels. There's a number of parcels in the area. If you can go to slide number 12, which Daniel did show us, these are a number of properties in the area that we found. Some of them have variances approved of them. Some of them were that legal non-conforming use, but we're not going to be out of character with what has happened in this general area with some with lots being under that 43,500 under the RU 43 zoning. Next slide will show you, I believe, number 13. We did get support letters with our adjacent letters to adjacent property owners to the north and to the south, and then one a little bit more north of us. So we did have support. We did walk the neighborhood, or Mr. Wise did, and talking to his neighbors to make sure that there were no issues. I know that we did receive some negative, some opposition that came forward, and I think that those were the property owners directly to the right or to the left on the west. And I know Mr. Wise can speak to that. They've known them for many years, and they talked about traffic coming forward, which we don't believe traffic is going to be an issue at all. And one of the things that the Wise family actually did with that property owner that's complained to the west is they actually have a buffer that they've built and even did some work on their property in regards to some of the drainage out there. And so there's been some back and forth with that property owner over the years, but we don't feel that the complaints that they brought up are warranted. But we do feel like our adjacent neighbors to the north and the south, they're supportive of it and don't have any issues with the proposal. We've discussed the situation with them. So with that, I think the next slide is just, that's it. So that's our case before you, and we're happy to answer any questions. I've got Mr. Wise here. Of course, he has been on the property since birth, and his family's been out there since the 1960s, so he can certainly answer any questions that you might have.
Is there any questions of the applicants? Okay, stating none, if we can then have Mr. Wise come up. Is there any people online that are going to want to speak to this?
We're not aware of anyone online who wishes to speak.
Okay, all right. So go, Mr. Wise, if you wouldn't mind stating your name for the record.
Yeah, George A. Wise. I'm the son of the original mother and father that owned the property back in 1964. They both passed away, and I'm the executor for me and my three brothers. So that's why I'm here, trying to get it done properly as my mom kind of wanted. But we understand, like he said, originally we wanted to, the will stated that the property adjacent, the complete acre property that's part of the L shape, was to be split in three ways. So we understand that's not possible because of the city variance codes, what have you. So we compromised. We just get a split. This way this acre stays, and the house and the shop on the property that he talked about, that they already had the variance, the lot to the corner of it can be sold separately. And that would settle the whole situation and develop it properly. That's what we're trying to do. And one thing I don't understand, I want to mention, is that house to the corner that had the previous variance. If you look at the map up there, it's not even like probably half acre. I don't know how that variance came about or when it came about. I mean, there was a later variance, and I believe in the 80s or 90s. There's nothing, if you go back in the records that I have found, in the 70s or 60s, when my mom and dad originally purchased the property, that house was not there. That, you know what I'm saying? So they originally purchased it separate from the original acre they had bought. I know it's kind of confusing, but that was back then. The county said, okay, it's legal. You can purchase this section before they even became part of this section. So I don't know, city records, what have you, Maricopa County, I don't know how that came about, but they did approve it back in the day. So basically we're going back to the way it was back in the 60s. The property split, if you want to look at it like that. I mean, that's what I can see and what I found to the record. So,
all right, thank you very much. Do you have anything else to say before we close public testimony?
I don't.
Okay, so at this point, we're going to close public testimony and open it up to any questions that the members have. So, any members have any questions? So this is in my district, but obviously I'm just one member. And so as I stated on the record before, is much as you want to try to be the ambassador of goodwill and try to help, I don't believe that we have the, we meet the requirements for approval of this case. But I will leave it open to the rest of the board so that they can opine in on what their feelings are and how they would like to move forward. Member Cardin?
Chairman Schwartz, thank you. Well, you know what I've heard today on this case is, in essence, we've got an L-shaped lot and we want to be able to split it so we can treat it like its own separate lot. And I feel like that's pretty different to the other cases we heard today, where, you know, you kind of had existing conditions and people who bought the property after the fact. I've owned a lot of property where I'd like to be able to get more lots on it, but it's have to do within the constraints of the regulations when you bought it. And so that's what I've recognized when I've bought the property. And so I guess I'm being long-winded and saying I'm having a hard time disagreeing with you here. I think I agree with you.
Any other questions from members for Sohn or Ward? So I have one quick question before we look for a motion. Darren, does the property owner has the ability to rezone the property, correct?
Acting Chairman, members of the board, he may seek to rezone.
That's what I meant.
Unlikely that staff would support a rezone for this spot.
Okay. All right. So this is in my district. I don't necessarily need to be the one to make the motion, but unless anybody else is okay. Member Cardin, go for it.
I'm just trying to help you out here. If you'd like me to, I'd be happy to make the motion to deny BA 2022-036.
Do I have a second?
I'll second.
Okay, we have a second by Member Ward. So can we take a roll call? Member Person, I'm sorry. We have a roll call?
Member Cardin?
Yes.
Member Schwartz?
Yes.
Member Ward?
Yes.
Vice Chairperson?
Yes.
Chairman, that's a approval of the denial of a vote of 4-0.
All right. Thank you very much. Yes, Darren?
Mr. Chairman, just for the record, the applicant, as the applicant's counsel will advise the applicant, he has the right to appeal the Board of Adjustments determination to the Superior Court.
Yes. Okay, great. Thank you. Can I take a question from the applicant at this point? He's raising his hand. Okay, not on the record. Okay. Okay. Is there anything else that you need to, that we need to be aware of before we adjourn the meeting? Yes. Everybody, we wish everybody a very happy and healthy holiday season. You know, God bless all of you and enjoy all the food and festivities with your families. And we look forward to ushering in the new year with you at our January hearing. And we are adjourned. Thank you.
Thank you.